You probably know him by now. Oh, he's not as famous as Kyle Rittenhouse, but he certainly made the news. This is Dominick Black, and he is Kyle Rittenhouse's best friend. He was the one that purchased the rifle that Kyle Rittenhouse later used to shoot 3 people, killing 2 of them. Keep in mind, Dominick never hurt anybody. But because Kyle got his rifle from him, he has been the central figure in a recent court battle for which he came out gloriously victorious. He was facing some serious charges. However, those charges were dropped to a simple municipal code violation, basically a speeding ticket. But that didn't stop a lot of people from getting hopping mad at Dominick because he testified on behalf of the prosecution. They labeled him a turncoat and claimed somehow that Dominick's testimony hurt Kyle. These same people claim that Dominick did not have to take the stand at all. Are they right? Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
Okay, so what we're talking about here is the Fifth Amendment. Did Dominick Black have to answer any questions at all? And the answer is, yeah, probably. A lot of people don't understand the Fifth Amendment. They think that, well, if I'm on the stand, I don't have to answer any questions. Not true. The accused doesn't have to take the stand, but if you've been subpoenaed as a witness, you're going to be up there, or you're going to be facing contempt of court charges. And Dominick Black was subpoenaed, so he has to show up. He has to take the stand. Now, does he have to answer all of the questions asked of him? Maybe. It all depends. He can take the Fifth Amendment on certain questions, and on other questions he cannot. So how do we tell which ones are which? Well, you have to go back to the fundamental principle of the Fifth Amendment, and that is that no one, even a witness, cannot be forced to testify against themselves. And by that we mean that they cannot be forced to answer questions that could implicate them in charges that have been levied against them or could be levied against them in the future. In other words, you cannot be forced to admit to a crime for which you can later be prosecuted. So there were some questions that were asked of Dominick Black that he could have taken the Fifth Amendment on. And there were many, most of them, he had no choice but to answer. And if he didn't answer them, he would have been facing contempt of court. So we have to ask ourselves, what charges was Dominick currently facing, and what could he have been charged with? Well, he was currently facing 948.602C, and that was the intent to give, sell, or loan a dangerous weapon to a minor. So here is 2C. I've actually highlighted B because it's important as well, but it says whoever violates paragraph B is guilty of a Class H felony if the person under 18 years of age under paragraph B discharges the firearm and the discharge causes death to himself, herself, or another. Of course, this also relates to paragraph B, so we have to read it. It says that, except as provided in paragraph C, any person who intentionally sells, loans, or gives a dangerous weapon to a person under 18 is guilty of a Class I felony. All right. So there are questions that could have been asked of Dominick that he does not have to answer because of this. So, for example, if it's not clear whether the gun was used to kill somebody, then any questions that were asked of Dominick about whether that would settle that question, he would not have to answer. Of course, the fact is that everybody knows that the gun was used to kill people. In fact, the defense applied an affirmative defense on that fact. They're admitting it because the only way that Kyle Rittenhouse can claim self-defense is if they admit that the gun was used in self-defense. So I cannot conceive of any questions that Dominick Black could refuse to answer by pleading the Fifth Amendment based on being charged under paragraph C. What about paragraph B? Well, according to what we have here, any question that would help incriminate him in a future trial where he is charged with giving the rifle to Kyle, he doesn't have to answer. So with some of those questions that were asked of him, he could have pleaded the Fifth. For example, did Kyle ask you permission? He doesn't have to answer that question. He can plead the Fifth. Where was the rifle stored? Well, it was stored in the trunk of Dominick Black's car, but if he doesn't want to answer that question, he can take the Fifth. Now, keep in mind, this all has to be worked out ahead of time. So there would be a hearing where Binger would have to divulge the questions that he wants to ask Dominick Black. Dominick Black would have to indicate which ones he's refusing to answer, and the judge would have to look at the nature of those questions to see if they could possibly incriminate him in future trials and make the decision. So this is worked out ahead of time, not in front of the jury. So, and I know what you're thinking. Well, why didn't he? Well, there's a number of reasons why doing so would be a very dumb thing. Let's suppose he takes the Fifth Amendment and he refuses to answer any question about how Kyle got a hold of the rifle. It does him no good whatsoever to do that. He's already testified to the police. What happened? They already have that testimony. It's on recording. So what good would he gain from it? They would just put the police officer up on the stand and the police officer would tell what happened. So in a future trial, it wouldn't do him any good at all. But I know what you're thinking. Well, wait a minute. What if it helps Kyle, though? But it doesn't. Kyle was facing serious murder charges and attempted murder and reckless endangerment. How he got a hold of the rifle is not really important. So pleading the Fifth would have protected Kyle none at all. And in fact, it would have made Kyle look even more guilty. Why is his best friend refusing to answer this question? There must have been something real insidious going on between those two. The jury would have simply inserted their imagination to fill in the gaps. Now, you may be thinking, well, wait a minute. What about the gun charge that Kyle was facing? The gun charge that Kyle was facing was all about his possession of the rifle, not how he obtained the rifle. And it's clear that Kyle would have been under 18. Nobody disputes that. And he was in possession of a rifle. Nobody disputes that. Therefore, if the judge had ruled that possession of a rifle by anyone under the age of 18 was illegal, Kyle is dead to rights. There's nothing he can do. Thomas Binger does not need Dominick Black's testimony to help him nail Kyle in that situation. The judge actually threw out the charge. So on all counts that Kyle Rittenhouse was facing, Dominick Black taking the Fifth Amendment would not have helped Kyle whatsoever and would have probably hurt him. Now, what about Dominick? Dominick has everything to lose here. If he takes the Fifth Amendment, he just simply angers the prosecutor, who's not going to cut him a deal now, and will probably ask for the maximum sentence. Now, the other question could be, what about the straw purchase? Well, in the previous video, I told you exactly why that purchase, even if it was a straw purchase, did not violate state law. It's right here. It states as clear as day, whoever intentionally furnishes, purchases, or possesses a firearm for a person, knowing that the person is prohibited from possessing a firearm under Section 941-29-1M, is guilty of a Class G felony. And that sounds like Kyle and Dominick are a little bit of trouble. However, Kyle was not prohibited from possessing the firearm under Section 941-29. In my previous video, we read it out loud. Therefore, the purchase of the rifle didn't violate state law, even if it was a true straw purchase, which it was not, in my opinion. So Binger could have simply given immunity to any future prosecutions under this statute because he knew very well that he couldn't prosecute Dominick Black for this anyway. Therefore, any questions related to the purchase, Dominick Black would not have been able to take the Fifth Amendment on. Well, not quite. The reason why is because Dominick Black could be facing federal charges for a straw purchase in the future. So we go back. At this point, it looks like Dominick Black could actually refuse to answer any questions related to the purchase of the weapon. Not because he faces future prosecution by the state, but because he could be potentially facing future prosecution by the federal government. So would he have done that? And the answer is no. It would be a very dumb thing to do. Again, Dominick Black has already testified to the police about everything going on with that purchase. The feds, if they want to prosecute Dominick and Kyle for that, they already have the evidence. And of course, Kyle shot his mouth off too. So the feds would already have the evidence they need. Taking the Fifth Amendment would not do anything. Furthermore, it would not have helped Kyle. The purchase of the firearm had nothing to do with the charges that Kyle was facing. So taking the Fifth Amendment would have done nothing for Kyle. It would have done nothing for Dominick other than anger the prosecutor. So what's the point? Looking at the trial, in which I went over the transcript of what Dominick Black actually said, nothing he said was very incriminating against Kyle at all. And so taking the Fifth Amendment, all it would have done is make Kyle look guilty and anger the prosecutor. So it's a dumb argument about taking the Fifth Amendment. It would not have helped Dominick or Kyle at all. Now, if Dominick and Kyle had never spoken to the police at all, never gave a statement, maybe. But it was too late for that. Like my video, subscribe to my channel, and quit going around telling people that Dominick Black should have taken the Fifth Amendment. Come on. Ridiculous.